Good morning. So, um, welcome. And we're going to do two things today. We're going to work through a couple of conveyances to make sure that you guys understand the process of translating a conveyance uh, into a set of interests, and then and also to illustrate some additional wrinkles in the law. And then I'm going to show you guys the midterm evaluation that I mentioned in the lecture on Tuesday. So let's get started. Here is the first conveyance. To A for life, then to A's heirs. So let me start by saying that every conveyance that we look at today is going to have something weird about it. Okay, so if you look at this and you think that there must be something odd going on here, you are correct. Okay, but the first thing that I want us to do, the first piece of this that I want us to do, is to actually figure out what the conveyance says. Okay, so that's the first step. And when you are answering these kinds of questions, when you are trying to explain a conveyance to someone, you don't have to go through all this process. You can jump straight to the final answer. But for today, I want to start with what the text says. Okay? So, what does the text say? We start with the present interest. So, who holds the present interest and what do they have? Right. Exactly correct. Exactly correct. Both Michaela and Gabrielle are exactly right. A has a life estate. Okay? So, according to the conveyance, according to the text of the conveyance, what future interest is created? And let me show you guys how to describe a future interest. So there are three pieces to describing a future interest. You have to identify the correct future interest. You have to identify the holder of the future interest, and you have to identify the possessory interest that comes into existence when the future interest vests. Okay? Does that make sense? So what's the future interest? That's the possessory interest that is created. Yes, that's correct. But that's not the future interest. Okay? Maisha, you're correct that reversions are future interests that are created by life estates, right? You guys remember that reversions and remainders are the future interests that are attached to life estates because they are certain to vest. So there's no uncertainty there. The future interest will vest at some point, okay, when the holder dies. What's the difference between a reversion and a remainder? Like, why do we call these two different things? What's the difference between them? Right, reversions go back to the grantor, remainders go to a third party, right? That's exactly right. That's exact. You guys, all of you are saying the correct thing. Great job. So is this a reversion or a remainder? Right, it's a remainder. Right, exactly. Who does it go to? Let me put the conveyance back in the chat for you guys so that you can see it.
Morning, sir.
Morning.
Does the remainder go to A's heirs?
That is absolutely correct, right?
Okay.
That's what the text says. Okay, and right now that's what we're asking is, what does the text say? Okay, that it's not as complicated as it might seem at the first step, where we're just going, what does the text say? Okay. So if all you're interested in is what the text of the conveyance says, here's how you would express the interests, right? So a life estate to A, a remainder to A's heirs in fee simple absolute, right? You have to identify that possessory interest. You have to identify the future interest. You have to identify the holder. Here is the wrinkle. Okay, here is the wrinkle. Who are A's heirs? Right, they don't exist until A dies. And so this raises an a difficult question for judges who are trying to evaluate this conveyance. And what happened in England when this option came into existence, this is a case called Shelley's case, okay? Shelley's case. And if you ask your classmates in other tutorials, some of them will say that I spelled it as Shelley's case. Both are correct. This case is from a time before English spelling was regularized, and so we see both. Doesn't matter. Same case. Okay. Here is the rule in Shelley's case. We have to have three conditions that are met. We have to have a single conveyance that creates a present freehold estate. And what that means, what we mean when we say a freehold estate is just not a lease. Okay. Any other present interest is a freehold estate. Okay. Present freehold estate. And the last condition, a future interest in the present holder's heirs. So single conveyance, one document, present freehold estate. That means fee simple, defeasible, or a life estate. Okay. Future interest in the present holder's heirs. We see these three things together, we merge the present interest and the future interest. Okay? So under Shelley's case, A takes in fee simple absolute. Okay? Here is the frustrating part that is going to frustrate some of you. Shelley's case doesn't apply everywhere. Some jurisdictions have rejected it. And so in those jurisdictions, you would express the interests created by the conveyance in the way that we did when we were looking at the text. But in jurisdictions where Shelley's case applies, you say A takes in fee simple absolute. Does this make sense? Seeing one yes. You can jump in with a no, it's okay. Sure, absolutely. So what do you need me to repeat? Okay, so to answer Maisha's question while you type, the second requirement for Shelley's case is that you have to have a present freehold interest, which means that you have to have some sort of present interest that is defeasible. Because if it's not defeasible, right, if you have fee simple absolute or a term of years absolute, there's no future interest, right? Well, that's not true. There is a future interest for the term of years, but again, that's not a freehold estate, okay? So, Maisha, does that make sense? Does that help more?
Yes. So you're saying, just to make sure that I get you, is that they have to have a present freehold interest. And all that means is that it has to be, they have to have, sorry, a present interest. It has to be defeasible.
Right. Has to
And
be
the
a
only
life
thing that
estate
we-
which is defeasible upon death, or a
Mhm.
fee simple defeasible, which is defeasible upon an event, or a fee simple subject to condition subsequent, which is defeasible
Okay.
on a change of condition, right? So those are your options.
Okay, just another question. In reading, I came up and I think in the worksheet, you mentioned the fee simple subject to executory limitations. Does that apply? I see you had it crossed out, but I wasn't too sure. Or the example you had, put a line through it. Does that apply as a present interest?
So an executory limitation is just another way of saying a fee simple defeasible. So those are,
Oh, okay.
yeah,
Oh,
those are different terms for the same thing. Okay.
Oh, okay. Understood.
Great.
Thanks.
Chanel, go ahead. You can. Okay. So you're feeling clearer now. Okay. Great. Okay. Ty, you've been very patient. I've not been ignoring you. Go ahead.
Hi, can you hear me?
I can hear you.
Okay, at some point, could you go over conditional and determinable fee simples? Because I'm having issues with understanding the difference between them because they're so similar.
Right, and you're absolutely right that they're very similar. And I think this is a great opportunity for us to transition to the next conveyance that I want to go over, which gives us an opportunity to talk about that in some more detail. So let's do that.
And I have another question with fee simples and fee tails. You know how in the notes it says in some jurisdictions they don't have fee tails, but in some of the questions that we had for homework, in some circumstances, like if we thought it was both, would we say in a jurisdiction where there's I don't know, in a jurisdiction where there is tail, there would be this?
So I don't have the homework in front of me, so I can't speak to specifics, but I can tell you that fee tails are disfavored.
Okay.
And so one of the things that we do to sort of express our disfavor in them is we require them to be specifically stated. So, you know, there are times where a poorly written conveyance will sort of be reformed by a court to try and like give effect to the intent of the grantor, even where they didn't use the magic words or best practices language. But with fee tail, we only allow it where the best practices language is used. And so that is going to be 2A and the heirs of their body. So there's going to have to be some language after the word heirs to indicate that it's limited to lineal descendants, right? So of their body is one, begotten of their spouse is another, or you can just explicitly state the estate and say 2A and the heirs in fee tail. But if the magic words aren't there, you don't have a fee tail. Does that answer your question? Okay, great. So now let's move on to the next conveyance, because this is going to give us an opportunity to talk about the difference between fee simple determinable and fee simple condition subsequent. Okay. Yeah. 2A, unless they become a lawyer, then to B until they marry, then to C and their heirs, so long as C never marries a Montague. Okay? So again, we're going to start with the text itself. Who holds the present interest and what do they hold? What's the language in the conveyance that makes you think that A holds a life estate? Nyasha? Is that the language of the conveyance, Nikila?
Hi, morning, sir.
Good morning.
I have a question. Would it be that the A holds a determinable, a a determinable in fee simple?
What makes you say that?
Only because it says unless they become a lawyer, or would that be conditional?
Well, I'm asking what about, I mean, I agree that that's the conveyance.
Uh-huh.
What about it tells you that it's determinable as opposed to condition subsequent? What makes you decide which side you want to come down on?
Well, it says unless they become a lawyer, and that's not something that is bound to happen. That could happen or couldn't happen.
Right, so it's not certain to vest, so it
Right.
could, it's certainly a defeasible fee, right? I agree with that. Which side do you think it comes down on?
I think it's a condition
Okay, why?
only because as I said, it could or couldn't happen as opposed to something that would happen. I'm not sure.
No. Both the fee simple determinable and the fee simple condition subsequent have an uncertain condition attached to them. We don't know that this future interest is going to vest. Okay. The only type of future interest that is certain to vest are future interests that follow life estates, because everybody dies. Right? So, so the distinction between certain and uncertain does not give us any helpful information, because everything is uncertain. So, what's the distinction between the defeasible fee and the condition subsequent fee? So, Maisha, you think it's a condition subsequent. What about what makes you think that?
Well, I am of that opinion because of the word unless. It stops or it continues unless it happens, I think. Yeah, so it would go to A. If A becomes a lawyer, then no, wait, hold a second. To A unless they become a lawyer. So if A becomes a lawyer, then it wouldn't go to A. So it stops when something happens.
So is
Stops
the,
when
go ahead.
no. Now I'm thinking to change my mind to a determinable.
Why
But,
what about, because you've sort of talked through your logic and now you want to change your mind, and that's fine. I'm not telling you you're wrong or right in doing this. I'm trying to draw out your reasoning. So what about your logic as you explained it, sort of made you go, wait, I don't agree with myself anymore?
because I am now one happens when something ceases to happen, and one happens when something begins to happen.
Right.
And now I'm now confused as to which one ceases and which one begins.
Right. Understandable. Okay. So, but you're right about the distinction, right? The distinction is that one is an event that happens, the other is an event that ceases to happen. So, do we have any? Nyasha, I see you. I want to finish this first, but I'm not ignoring you. Do we have anybody who can remember which is which?
Hi, sir. The conditional subsequent is the one that ceases, and the determinable is the one that happens.
That's correct. That's correct. So now that we have that in mind, right, now that we've sort of laid out the basis here, what do we think is the type of interest that A has? Is it a determinable or is it a condition subsequent? Maisha says determinable. Does anybody want to jump in and argue for a condition subsequent? Esha, I saw that you said that it was conditional. That was before all of this conversation. So, you know, a lot of you guys have pointed to the prepositions, right? This isn't something that only Esha says, right? This is something that a lot of you guys say. And I will tell you the same thing that I told everybody else. You will find cases where the judge sort of throws up their hands and says, we're just going to rely on the language and the prepositions give us what we need to know. And, you know, there's a list of prepositions that are determinable. There's a list of prepositions that create conditions subsequent. And I am here to tell you that those cases are engaged in a very shallow and incorrect analysis. The Professor Owusu says, McGarry and Wade says, Cheshire and Gray says, right? You know, all of the authorities say that the question that you're answering when you're trying to define this distinction is what's the intent of the grantor? And the intent is expressed through the event, not through the language. So I absolutely understand how getting to how, you know, looking at the words gets you that conclusion, because you will find cases where the judges do that. You remember how last week I mentioned that that stupid people convey property all the time, and it's our job to figure out what they meant to do. Well, there's a lot of judges who don't engage in sort of deep, good analysis, right? And I hope that you never appear in front of any of them. And I hope that, frankly, there aren't any of them by the time you're practicing. But we know that they do exist, right? So, and so you should not, you should be careful about relying too heavily on the prepositions. Look to the event in question, okay? Maisha, you've had your hand up. I appreciate your patience. Go ahead.
Yes, I too in the beginning was looking at the preposition, and so I was saying that it was fee simple condition. But when you explained it before you asked again, I asked the question: is being a lawyer something that happens, or is it something that ceases to happen? And I said that becoming a lawyer is something that happens because she never was a lawyer. So they're saying unless they become a lawyer. So it would be a determinant.
Right. Now, we could write the conveyance in such a way that the same event triggers a condition subsequent, right? So we could say it we could write it as 2A so long as they never become a lawyer. And that would create a condition subsequent, because then it would be an ongoing condition that ceases to be true. So that you're absolutely right that the way the conveyance is written, it creates a fee simple determinable. So let me put the conveyance back in the chat. Okay, so that's the present interest, right? A holds a fee simple determinable. Okay. And again, like we discussed, the difference between these two is really fuzzy. It's hard to discern. And so I am not super concerned with whether or not you are whether or not you're assigning the correct label to the present interest. So what happens when the conveyance states that it is determinable but is written as if it's conditional? What do you mean by that, Ty?
What I mean is, like, if it states clearly that it says this is determinable, but then it's written with the words as if it's conditional, like, and
So,
then both
so
kind
like
of,
it says 2A in fee simple determinable so long as they never become a lawyer.
yeah. So then you're kind of like with both, but you're not sure. Like, I don't know if
Yeah.
that actually happens, but
Yeah, so I think that, the goal in all of these, in sort of figuring out what interest is conveyed by a conveyance is to express the intent of the grantor. And the magic words don't necessarily, like the names of the interests don't necessarily convey intent, but the depriving event conveys intent. So I would argue that the condition, right, the defeating event is what determines the interest, not whatever label you put on it. Does that answer the question?
yeah, kind of, because one of the main differences in the book states that it's like the language that is used. It just makes it so difficult to, if there's both, then what do you do? Because there's no language really to tell the difference because it says the same thing.
Yeah. Yeah, again, like I think that we try and give effect to intent even where people aren't, even where people don't understand what they're doing, right? And so the use of and the name of an interest that doesn't match the condition that's being assigned is a suggestion that the person doesn't understand what they're dealing with. And so we would want to sort of make sure that we're giving effect to the condition as it's expressed rather than the perhaps erroneous label that's being put on it. Does that make sense now?
Yeah, it does. Thank you.
I think it's easier for people to mess up labels than to mess up what they intend to happen. And so we should prefer, where there's a conflict, we should prefer their expression of their intent over their use of labels. Okay. There may be authorities out there that disagree with me, but that's kind of what I think. Okay. All right. So, one second. It scrolled, the conveyance scrolled back off as we were discussing this. So let me put it back in. Okay. So we have the present interest down. What future interest is created? Because, with a fee simple determinable, you have to have a future interest. So what future interest is created by A's fee simple determinable?
Hi, sir. I don't know if I'm correct, but it sounds like a remainder, but also a determinable.
Well, I
Sorry?
think you're right about the possessory interest, right? Because
Okay.
again, it's a specific event that happens, okay?
Right.
But remainders are attached to life estates. So what is
Okay.
the future interest that attaches to a fee simple determinable? Maisha is correct. It's a possibility of reverter. Who holds that possibility of reverter? Johnny, you came off mute. You got something? Johnny, you there? If you're talking, I can't hear anything you're saying. I would suggest getting closer to the mic. Okay. So we have a possibility. Can it be a re-entry? So re-entries don't attach to fee simple determinables, right? They attach to fee simple subject to condition subsequent. So remember that there's not that the right of re-entry attaches to a specific sort of present interest. There's a reason that these things attach in certain ways. So yes, so possibility of reverter to be in fee simple determinable. Okay. So again, the possessory interest is a fee simple determinable, right? So coming back to the conveyance, there has to be a future interest. What's the future interest attached to B's fee simple determinable? What's the future interest attached to B's fee simple determinable? That Maisha, that statement doesn't express any possibility of reverter, right? To whom, in what? Why do you say that C takes in fee simple absolute?
Oh, sorry, I forgot the last part that says, so long as he never marries.
Okay, so what do you think?
I'll
What
have to
now?
look at it.
I'm sorry?
I say I'll have to look at the scenario, the conveyance again.
Okay.
Can you repeat the last thing that you asked to see?
What
I
is
forgot.
the future interest that attaches to B's fee simple determinable? So as with everything, right? Future interest to the holder in the possessory interest. Got to give me all three pieces of information. So Michaela, you say that it's to C in fee simple determinable. What is the future interest? And why do you say that it's determinable? Go ahead, Maisha.
Oh,
Yes, just to clarify, I think I mixed up something. We say that A holds a fee simple determinable. That's the present interest.
Right,
The future interest is a possibility of reversal to B, correct?
yes.
Yes, possibility of reversal to B.
You have
And
not,
then
you
the
have not
question
finished
now,
describing B's future interest. You
oh, the
have
future
to,
interest of,
describe the
oh,
possessory
okay.
interest that's attached. So possibility of reverter
The
to be in,
possessory interest. Oh, because it goes to a possibility. When it reverts to B, what does B get?
right,
That's the question you're asking. Okay,
right.
and if he has a possibility of reversal, it goes to B, and B then gets, oh, that's the scenario. Simple determinal.
Right, which means that there has to be a future interest, which is now what we're talking about. Okay,
Oh, okay.
so Michaela, you've been very patient. I appreciate that. Go ahead.
right. I was just gonna say that the future interest might be oh shoot, I lost my train of thought. Hold on.
Sir, would it be a future interest in fee simple determinable? Because it says until they marry.
That is that. Well, that's B. Right. So what is the what is the defeasible condition for C's interest? Johnny, you're muted if you're speaking. So. So what is the condition that attaches to C? Possibility of reverter to C, right? Maisha, that's correct. But what's the possessory interest, right? That's the last step of describing the future interest.
Sir, wouldn't it also be a fee simple determinable?
Okay, why?
Because it says so long as C never marries.
So is that a condition that would cease to be true, or is it an event that happens? So Chantel says it's a condition that ceases to be true. I can tell you that's how it's intended to be written. There have been a number of people who have argued that this is a fee simple determinable because the marriage is an event. I am sympathetic to that argument, but I think the better argument is that the expression of the condition is that it is that the world needs to be one where C has never married a Montague. And on the date that C marries a Montague, they cease to live in the world where that condition is met. And so that triggers the next step in the conveyance. Okay, and what is that next step in the conveyance? So first of all, what's the future interest? Somebody come off mute and say it. We don't have time to wait for you to type. What's the future interest?
Possibility of reversal. That's what we said.
If it's a fee simple subject to condition subsequent, what is the future interest that attaches?
Oh, right of entry.
Right, who holds it?
It would have to be B.
Why?
Because that would have been the person that they would have gotten it from. Or does it go back to the first?
It goes all the way back to the original grantor, right?
Oh,
Because
right.
if it doesn't say who it goes to, you can't put somebody into the chain of title that's not there unless they're the original grantor, right? Because the original grantor is in the chain of title all the way at the very beginning. So if the conveyance doesn't tell you who gets it, it's always the original grantor.
Okay.
And what possessory interest does the original grantor get?
Fee simple absolute.
Exactly, right. So we're out of time, so here's the wrinkle. We don't like restraints on marriage in property law. We don't think it's right that you should be able to control who your grantees marry by divesting them of property. So a complete restraint on marriage is void, which means that everything after the conveyance to be just falls away because that condition never gets met because it is void. So A takes in fee simple determinable, and then B has a possibility of reverter in fee simple absolute. Okay. But here's the other wrinkle, and then I'm going to let you guys, go. Partial restraints on marriage are okay. So we let people say, I don't want you to get married until you're 25. If you get married before you're 25, I'm going to take away this piece of property I'm giving you. We let people say, I don't like your no good, lazy boyfriend. I want you to marry somebody else. And if you marry him, I'm going to take away this piece of property. We let people say, I really hate the Montagues, and so I don't want you to marry a Montague. And if you marry a Montague, I'm going to take away this piece of property, right? Those are all valid restraints on marriage. Okay. That I'm going to show this to you. It's going to take seconds. Okay. So that's it. Okay. Is partial restraint on marriage good? Complete restraint on marriage, bad. Okay. So now let me show you the midterm evaluation. And this is not an exam. This is not an assessment. This is something for you guys. So this is not. So, all right, let me share the screen. Okay, so you go onto the course website here, and you scroll down to this week's calendar block. Click on midterm course evaluation. And this is just it's 8 questions, and it's really just intended to give you an opportunity to tell me the things that are working for you in the class, to tell me the things that aren't working, because I want to do more of the things that work. I want to do less of the things that don't work. So with that, I will see you guys this afternoon, and take care. All right, bye.